Welcome back to the video lecture on East Asia's cultural influence on the law of the sea. This time, we are going to speak on the recent trend of the attitude of ASEAN states towards third-party adjudication in terms of the Japan. And we are going to focus on the Fukushima nuclear power plant contamination water discharge. On March 11, 2011, an earthquake occurring in the seabed near the northern region of the Japan that damaged the internal facilities of the Fukushima Daiichi nuclear power plant, causing the release of a significant amount of radioactive material. In March 2013, the Japanese government installed the Advanced Liquid Processing System, in short, ITLOS, and stored the radioactive wastewater in storage tank near the nuclear power plant. Subsequently, on April 13, 2021, during a meeting of ministers, the Japanese government officially announced the confirmation of its plans to release the radioactive wastewater stored at the Fukushima nuclear power plant's accident site into the Pacific Ocean over a period of 30 years. On July 22, 2022, the Japanese Nuclear Regulation Authority approved Tokyo Electric Power Company's plan to release the Fukushima nuclear wastewater into the ocean. Consequently, it is anticipated that the formal release of the nuclear wastewater into the ocean will commence sometime after July 2023, following the completion of discharge facilities, including the undersea tunnel, and this was actually happened in August of 2023. The Japan's position can be summarized into three key assertions. The first, Japan did not violate the United Nations Convention on the Law of the Sea, UNCLOS. Although Convention imposes the general obligation on contracting parties to protect and preserve the marine environment and mandates legislative action to prevent, reduce, and control pollution of marine environments from land-based sources, it also recognized the broad discretion of contracting states in such matters. The second, Japan asserted that it did not violate the London Protocol regarding the prevention of marine pollution, which prohibited dumping of waste and other matter. According to the protocol, dumping means any deliberate disposal of waste or other matter into the sea from the vessels, aircraft, platforms, or other man-made structures at sea. As such, the discharge of contaminated water from land-based nuclear power plants falls outside the scope of dumping. The third, the contaminated water that Japan wants to dispose of pose no harm to the marine environments or human health and is comparable to the emission practices of neighboring countries such as Korea. As a result, Japan maintains that none of its discharge plans are in violation of international law. The scientific and objective verification of the planned discharge of contaminated water is essential. While Japan emphasized that most radioactive substances can be removed from the water through the Advanced Liquid Processing System, ITLOS, it acknowledged that tritium would not be filtered. The scientific community has remained divided on the potential hazard and harmful effects of the accumulation of tritium on the marine ecosystem and human health. After 5 separate on-site investigations in Japan, the International Atomic Energy Agency's IAEA reported that it affirmed the independent role and function of Japan's Nuclear Regulation Authority and stated that it would continue monitoring Japan's compliance with international standards. However, adherence to international standards alone is not evidence of conclusive scientific justification. If there are inherent risks associated with the release of the contaminated water, the sufficient scientific evidence cannot be deemed to be present. The issue of discharging contaminated water must be considered as an international issue, since the discharged wastewater will circulate through ocean currents, and neighboring countries like Korea, as well as the Pacific coastal states, which are likely to be exposed to residual radioactivity materials. For example, the IAEA highlights the need for Japan to provide supplementary explanations regarding its radiological environment impact assessments and the potential consequences of wastewater discharge. In the light of the lack of clear scientific evidence regarding the safety of treated contaminated water, concerns have arisen among neighboring countries regarding the potential risk posed by the discharged wastewater. In response to Japan's unilateral decision to proceed with the discharge without prior consultation with adjacent countries, various measures are being discussed in terms of international litigation. Such measures include interim measures and substantive proceedings before the International Tribunal for the Law of the Sea, initiated by a sovereign state, as well as by opinions from the International Court of Justice or the International Tribunal for the Law of the Sea. For the ITLOS to decide upon the provisional measures, the urgent risk and serious harm to the right of the parties concerned need to be demonstrated. Although Japan has formally announced its plans to discharge, the establishing the aforementioned requirements in the absence of an actual discharge pose a formidable challenge. Similarly, in the substantive proceedings, the Japan's violation of international law regarding the discharge of radioactive contaminated water from Fukushima must be addressed. The plaintiff state must proceed with legal procedures premised on Japan's breach of international legal responsibility. In order to establish state responsibility, two essential elements must be satisfied. The first, the problematic act must be attributable to the state under international law. The second, it must constitute a breach of the state international obligations at the time of the act. Intent or negligence is not included as elements required to establish the state responsibility. Regarding the breach of international obligations, such obligations are set forth in treaties, customary international law, general principles of law recognized within the international legal order, and unilateral act of state. It is imperative to emphasize that the establishment of state responsibility is dictated by international law, and any contention by a state that its actions were lawful under domestic law does not absolve it from responsibility for an international wrongful act. The issue of whether Japan has violated international law regarding the discharge of radioactive contaminated water arises from Japan's failure to fulfill the procedural obligations regarding international cooperation, including prior notification or provision of information and conservation of the marine environment, including the exclusion of an environment impact assessment. This issue is also closely related to the ongoing lack of communication among the parties involved. Ultimately, from an international legal perspective, the litigation is highly likely to focus primarily on the procedural aspect of Japan's alleged breach of international obligations rather than on the aftermath of the contaminated water. In cases requiring scientific evidence, it is imperative to acknowledge the likelihood protracted litigation potentially failing to preserve the discharge of the contaminated water, and even if successful, its efficacy in sanctioning Japan's actions may retain uncertain. Moreover, the ambiguity surrounding which sovereign state would initiate legal proceedings within the context of the international dispute resolution add complexity to the matter. Recent developments in climate change issues has seen in the International Court of Justice and International Tribunal for the Law of the Sea play significant roles in providing advisory opinions, drawing attention to the stance of Pacific Island nations, which are formerly nuclear testing sites. Despite the legal significance of the advisory opinions from the international judicial bodies, it is difficult to consider such a method as effective means to prevent Japan's discharge of contaminated water. Regarding the maritime areas beyond the national jurisdiction of individual states, the constantly evolving norms of the international marine environment have adopted a forward-looking stance. The argument that the discharge of radioactively contaminated water from a nuclear power plant is simply not a violation of international law and is comparable to emission standard of neighboring states hinges on strategic and selective decisions made by initiating state party during the international litigation, which may be contingent on prevailing circumstances. Thank you very much for your kind attention.